Hello everyone, my name is Anni Lietonen. I work as a researcher at HEUNI with a background in sociology. I'm also currently working on my doctoral research project at Åbo Akademi. So one of the primary goals in our E-ViVi project has been to develop really concrete, practical best practice recommendations for criminal justice professionals across the EU. Now, there is still relatively little research out there, particularly when it comes to communication in these remote settings. And that is why we wanted to hear from the professionals themselves. How is the increasing digitalization of criminal proceedings actually affecting the encounters and hearings between the parties involved? And how can we help strengthen their capacity in this changing landscape? So in this lecture, I'll be sharing some selected findings from our data. So let me walk you through how we actually collected the data that has informed our recommendations. Our main goal was really to hear directly from the people who work with remote hearings every day. I mean judges, prosecutors and lawyers specifically, also victim support organizations. The data collection methods were the same in each 3 partner countries, that is Finland, Sweden and the Netherlands. So this allows us to do some little comparisons between the 3 countries. However, due to differences in our legal and geographical landscapes, we had to be really careful not to over-interpret the information. Also, the survey sample we have is not statistically representative, as we aimed to make an explorative study here. So we started with the survey. In total, we have 267 professionals across the 3 countries that responded to our survey. They were pretty evenly split between men and women, with a small number of respondents who preferred not to specify. The survey combined fixed choice questions with open-ended ones where they could explain their views in more detail. But we felt that the survey could only take us so far. Hence, we also conducted thematic interviews with 36 professionals, asking them what it's like to communicate in these remote settings. What works, what doesn't, what gets lost. And then in each country, we either held a roundtable with victim support organizations or we had bilateral meetings with victim lawyers. We did this because we wanted to make sure we were also hearing from those who work most closely with victims throughout these processes. So first, I'll share some descriptive charts from our survey. We asked respondents to what extent do they agree or disagree with the statement that defendants perceive legal processes as equally fair when they are heard remotely. And just to clarify here, we asked professionals to reflect on these questions on behalf of defendants. So these are the subjective beliefs and perceptions of the professionals. Looking at the responses by Finnish professionals, the dark blue bar here, they are strongly leaning towards agreement, around 50% somewhat agreed and nearly 20% fully agreed. Swedish respondents were more spread out across the scale, with the largest share falling in the somewhat disagree or neither agree nor disagree categories, meaning that they were a bit more uncertain or a bit more skepticism among the Swedish professionals. Responses from the Netherlands are also more concentrated towards disagreement or neutrality. So clearly fewer are fully agreeing with the statement. Next, we also asked the same question, but this time professionals were reflecting on behalf of the victims. The overall picture is somewhat more positive than for defendants. Respondents generally believe remote hearings can be perceived as equally fair, but this varies considerably across the countries. Finnish professionals, again, the dark blue bars here are the most confident in this regard. Dutch respondents are most skeptical, and notably a large share across all 3 countries landed on neither agree nor disagree. So there is genuine uncertainty. Swedish respondents fall somewhere in between, showing a cautiously positive view. The key takeaway here is twofold. Perceptions of fairness seem to depend on national context. Also, fairness is not automatically perceived as something universally inherent in remote hearings. So for these reasons, practical recommendations and professional training does matter. Perceived fairness can be linked to professionals' competence in communicating remotely, and this is something that we can definitely work on. Another survey question we had aimed to understand how judges actually do in terms of communication when conducting remote hearings. Specifically, we wanted to know how routinely are certain communicational elements performed in hearings. Responses summarized here are the combined results across the 3 countries and all criminal justice professionals. In general, some things are clearly routine. It seems that judges consistently greet the parties, introduce those present, they explain the procedure and reassure parties that it's okay if they don't remember everything. These seem to be well-established standard practices. But when we move beyond those basics, things become less consistent perhaps. Explaining the role of each professional or instructing parties on how to signal if they don't understand a question or that they need a break, these happen far less regularly. And then there are practices that are rarely done. These are linked to emotions, perhaps more, well-being or support during testimony, explicitly acknowledging that the process may be stressful or that it's okay to ask for a break or consult with a lawyer. These appear to be the exceptions rather than the rule. And in a remote setting where nonverbal communication is less apparent and it's already harder to read the room, this finding becomes even more significant. We also asked whether remote hearings affect judges' ability to lead the process. This table shows responses from judges themselves, and the second one shows responses from lawyers and prosecutors. What's striking perhaps here is how aligned the responses are between the judges and the other professionals, so judges seem to be able to reflect on their own work rather well. Close to 60% of both groups feel that remote hearings have had some negative impact. At the same time, over 40% don't see a significant difference. So we could perhaps interpret this so that for most professionals, remote hearings work just fine in this regard, but also a small number even perceived really positive effects. And the last survey finding I wanted to share in this lecture was that I wanted to highlight when we asked professionals whether they expect remote hearings to increase significantly over the next 5 years. And the answer was a pretty resounding yes. Overall, 82% either fully or somewhat agreed, which tells us that those working inside the system very much expect remote hearings to be part of the future. There are some country differences, though. Sweden is the most convinced at 88%, while the Netherlands is the least optimistic at 57%, though that is still a clear majority. Another important survey finding was that 91% of respondents had not received training on remote hearings. So let me take a moment to summarize what the data has shown us overall. Remote hearings are generally viewed as procedurally fair for both victims and defendants, but skepticism remains. We've seen that judges handle the procedural and administrative side of communication rather well, but the more human and supportive elements, like acknowledging stress, emotions, and the need for breaks, are often missing. Furthermore, views are roughly split 60-40 on whether remote hearings affect negatively on judges' ability to lead proceedings. And across all 3 countries, but particularly in Finland and Sweden, professionals broadly expect remote hearings to become increasingly common in the years ahead. All of this highlights the work of developing practical guidance for professionals. So now I want to turn to what the interviews told us. I'll be starting with the context a little bit. The interviewed professionals in both Finland and Sweden had extensive experience with remote hearings. Particularly in the northern regions of both countries, remote technology has actually been in use for quite some time, simply due to the long geographical distances between the courts. The pandemic then accelerated this significantly, and for many, remote hearings have become what interviewees themselves described as the new normal. The Netherlands does tell us a little bit different story. Dutch participants reported that after the pandemic, practice largely shifted back to in-court hearings, with remote hearings now used only for more formal and non-substantive matters. And even between Finland and Sweden, differences emerged in the interviews. Sweden has seen a widespread post-pandemic adoption, while Finland appears to have maintained a somewhat stricter approach to when remote hearings are used. This can be linked to differences with technological infrastructures, as countries have different solutions and systems, some working better than others. When it comes to how the interviewed professionals actually experienced remote hearings, both benefits and risks were discussed. On the positive side, interviewees highlighted increased efficiency, greater access to justice, reduced travel, more flexibility, and in some cases, reduced stress and anxiety for parties. Some also noted that practical features like zooming the camera can actually enhance communication by providing a closer view of the person speaking. Many also talked about experiences where genuine risks and communicative challenges had been present. So flexibility can be great, but when does it actually risk weakening communication and the perceived fairness? I'll share a few quotes from the interview data. This first quote touches on something that came up quite a few times, whether parties who participate remotely genuinely feel that they are seen and heard during the hearing. A Swedish judge put it this way: "I think there is a risk that the person participating remotely does not feel seen or heard, or that they are not given the same opportunity to speak as those who are physically present. It's simply more distant." It was discussed by quite a few professionals that online setting can create a kind of psychological distance from the process. Parties may feel less connected, less present, less part of what's happening. Interviewees also raised concern about what happens when no one actively checks in. If a remote participant goes quiet or seems disengaged, it can be far too easy to simply move on, especially if there is time pressure. We know that interactions face-to-face can be a lot richer in comparison to online environments. Through the screen, it's much harder to tell whether someone is still following or still comfortable. So this next quote comes from a lawyer in the Netherlands and speaks to something slightly different. Not just whether parties feel present, but what professionals themselves lose when hearings move online. Listening goes all right, but I think following the interactions properly is really difficult. And I really think that's a shame. And I also find it important in court. How do people react to each other? The reactions of my clients and a public prosecutor or attorney general can also be very important. So this next quote comes from a Finnish lawyer, and it brings us another theme that emerged in the interviews: the challenges of rapport building and offering genuine support in a remote setting. I often have clients who have said that they feel that they have not understood the instructions they receive, either during pre-trial investigation or after, because they have been in some way shocked all the time. And I do believe that they have not been deliberately indifferent. Informing the clients and then the authority explaining the matter in a plain language repeatedly and calmly so that they understand the situation is important. So this quote is a good reminder that in criminal proceedings, people are often in a state of stress or shock. And in that state, information simply doesn't land the way we might want it to. From the meetings we had with NGOs and victim support professionals, we aimed to better understand victims' perspectives. Concerns were raised that victims may simply not have the information and support they need when participating in remote setting. And their needs, as we know, are not one-dimensional, but needs may vary from practical, the emotional, and the safety-related aspects. And having support in the proceedings is especially important when it comes to vulnerable participants. Across the 3 countries, the message was the same. Remote hearings can genuinely protect and benefit victims, but only if they are designed with victims' needs actively in mind from the start and not an afterthought. The participants need to make informed decisions related to the format of the hearing as well. Support services must be proactively connected to remote participants. We cannot just assume that the support is available to someone attending in person in the same way as for someone joining from a screen at home or wherever they may attend from. Lastly, the victim perspective needs to be much more explicitly built into the design of remote proceedings, from how virtual and physical waiting areas are set up to debrief possibilities after testimony to the specific needs of participants with vulnerabilities. So, from this rich data, we have been able to put together recommendations for remote hearings. I have just selected a few in this lecture, but the full recommendations are available from the E-ViVi project page. I'll start with the fundamental question of when remote hearings are actually seen as appropriate. Based on our data, they are most suited to situations where there are safety concerns, referring to situations where there's fear, threat, or excessive stress from attending in person. Also, when practical barriers exist, such as long travel distances, care responsibilities, or prison transfers are unpleasant or unwanted by the defendants. Also, when vulnerability calls for it, meaning that participants who have disabilities or are in protected locations, they may be better served in a familiar environment. And also remote hearings seem to be well suited for expert witnesses and hearings involving minors, where there is generally more flexibility. The underlying principle is that the decision should always be made case by case. The data also told us that the threshold for stopping a hearing may be quite high. We came up with a few clear signs for when a hearing should be paused or stopped because of continuing could lead to unfair or harmful outcomes. For example, hearings should not continue if there are unauthorized people in the room at the remote location, if the technology is poor, or if someone is joining from a distracting place like a car, metro, or a public space. We heard many examples that honestly sounded hard to believe. There were cases where family members were sitting and whispering what to respond during the remote hearing. People were attending while driving, and even a situation where defendant and plaintiff in a domestic violence matter were accidentally placed in the same room to attend from remotely. So the findings implicate that fairness depends not only on technology, but communicative competence as well. We have several lists in the recommendations that aim to support professionals in building this competence. I've added a few examples here that include the importance of clearly introducing all participants at the start, and when necessary, repeating that during the hearing. It's important to designate someone other than the judge to manage the technology. Pausing deliberately after a participant finishes speaking and speaking very calmly, letting participants know how to request a break or inform of difficulties, using also verbal feedback instead of nodding or gesturing, and establishing eye contact with the camera, not just the screen. Also, it was suggested that it's important to preset camera angles and also acknowledge what the participant perspectives are. So, when technology works, remote hearings can even be better than the real thing. This was something mentioned by the professionals in the interviews as well. I've added a quote here from a Swedish judge saying that these days we talk about taking a bemötande perspektiv, which can be translated roughly to participant-focused approach in court proceedings. And remote hearings is a good tool for that, also for witnesses who often find the situation unpleasant and for injured parties. By conducting the hearing in this way, the court has many more tools to work with, and the trials run smoothly as a result. Feel free to familiarize yourselves to the recommendations available on our website. Thank you very much for tuning in.